Quickie running. We've seen a lot of weird cases where government has sued inanimate objects. Here's one case where one of the inanimate objects sued back. Okay, the owner did, but that's not how the case title reads. It's 1958 Plymouth Sedan v. Pennsylvania. In 1960, police in Pennsylvania pulled over a 1958 Plymouth Sedan belonging to George McGonigal because it was riding low. And all his friends know the low rider. So, without a warrant, they searched it and found untaxed liquor in the trunk. The car was seized and confiscated as a civil penalty. McGonigal's criminal case was thrown out because of the exclusionary rule, which says that evidence obtained in violation of the Constitution cannot be used in criminal court. They also threw out the civil case on the same grounds. But the Superior Court of Pennsylvania reversed that, saying that the exclusionary rule only applies to criminal prosecutions and not forfeitures. The state Supreme Court upheld that. In 1965, the Supreme Court found in favor of the sedan, saying that the Fourth Amendment applies to civil actions as well as criminal ones. Justice Arthur Goldberg, delivering the opinion of the court, wrote, "If the government prosecutor elects to waive an indictment and to file a civil information against the claimants, that is, in civil form, can he, by this device, take from the proceeding its criminal aspect and deprive the claimants of their immunities as citizens, and extort from them a production of their private papers, or, as an alternative, a confession of guilt? This cannot be." The state tried to claim that surely there's no way the state can be forced to return contraband, but while that could apply to the liquor, as Goldberg pointed out, there's nothing illegal about owning a car. In fact, a civil action might be worse because the value of the item seized could be more than a criminal fine for the same offense. In this case, McGonigal was faced with a maximum penalty of a $500 fine, but the car was worth twice that. So that really explains why they'll generally seize the car without charging someone with a crime. It's an unintended consequence. If they charge the person with a crime, the seizure might be invalid under Sedan v. Pennsylvania. Civil asset forfeiture is definitely something that needs to be fixed.